afternoon. Thank you very much for joining us for this fourth European Law interview. This is the last interview of our first series on Articles 34, 35 and 36 of the TFEU. This interview is sponsored by the Jean Monnet Chair, which is part of the EU Training and Education Programme promoting innovative learning programs related to EU studies. We have the great opportunity today to interview Professor Nicolas de Sadeleer. He is professor in EU law and in environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good afternoon, Professor. Thank you very much for joining us. We will discuss today grounds for justification and in particular Article 36. If you don't mind, I'm going to read Article 36 for the students watching us. Okay? Yes. So Article 36 reads, the provisions of Article 34 and 35 shall not preclude prohibitions or restrictions on imports, exports or goods in transit justified on grounds of public morality, public policy or public security. The protection of health and life of humans, animals or plants, the protection of national treasures possessing artistic, historic or archaeological value. Such prohibitions or restrictions shall not, however, constitute a means of arbitrary discrimination or disguised restriction on trade between member states. We will start with a fairly general question. So, can you please tell me if the principle of the free movement of goods is absolute?
No, not at all. It's fair to say that there is no general freedom to trade. So Article 34 or Article 35 does not enshrine right to unhindered pursuit of commercial activities. So again, these two provisions are about removing restrictions on trade and not about deregulating the domestic economy.
So if it's not absolute, does it mean something regarding the environment?
So far, the treaty drafters have never been paying heed to the need to modify Article 36. So Article 36 harks back to the GATT treaty. So it encompasses the same grounds for justification to maintain or to adopt national measures hindering free trade. So far the drafters of the different treaties that have been modifying the Treaty of Rome of 1957 have never been at pains in placing the environment concerns as a genuine ground for justification.
Okay, so you just mentioned Article 36. Can you please tell us what it encompasses?
As far as environmental policy is concerned, it's fair to say that many environmental measures do encompass also a public health approach. So to speak, environmental concerns and health concerns are constantly intermingled. They are intertwined to a great extent with respect to air pollution, to waste management, to water pollutions. Most of the national measures or the EU directives are aiming not only at protecting ecosystem, but are also aiming at improving human health.
Can you please give me a concrete example related to health policies?
For instance, in the Tulex case, the Court of Justice was called on to adjudicate on the validity of a Swedish measures prohibiting a chemical dangerous to the health of the workers working in the CD industry. However, it must be noted that that chemical entails also important ecotoxic risks. So one understands that health issues do overlap environmental issues. So it's extremely difficult to draw a dividing line between what belongs to health and what belongs to ecosystem protection.
Can you give a more concrete example relating ecosystem protections in animals?
Well, pesticides. Many measures, national measures before the harmonization took place at the EU level restricted the placing on the market of different pesticides, and most of these measures were aiming both at enhancing health protection as well as protecting different ecosystems.
So does Article 36 offer the best solution to member states?
In that connection, yes, it does. In as much as the member state is ready to demonstrate that the national measures is aiming at protecting human health.
What about tigers and beautiful baby seals? Are member states allowed to regulate on this? How does it work?
Well, firstly, the member states have to take into consideration whether the area has been subject to harmonization. So whenever the harmonization is deemed to be complete, the member states have to apply the EU rules in their own right. So perhaps they have to consider whether these EU rules allow them to enact more stringent measures, but they can enact their regulation just with respect to the rules laid down by the EU institutions. So when the subject has not been harmonized, and that will be the case for different taxa of snakes or frogs, member states are empowered, according to the principle of subsidiarity, to lay down their own wildlife requirements, in addition to the requirements placed by the Habitats Directive. Okay. So one is facing a double approach. On the one hand, the Habitat Directives that's restricting trade in some endangered or vulnerable species, and on the other, member states' intervention with respect to species that are not regulated by the Habitat Directives. And so in so doing, the member state can justify the measures on the ground of Article 36 that actually refer to the protection of the health and life of animals and plants.
Would you mind giving us a more concrete example?
Well, for instance, the protection of domestic crayfish, that is a threat by the American crayfish. German measures aiming at limiting the import of exotic crayfish were deemed to be justified on the ground of Article 36.
Okay, that's much more clear now. What about recycling targets, for example, renewables? I assume that they do not fall within the scope of ambit of Article 36.
Your question is very relevant, in particular, given the growth in renewable energy, in recycling requirements. The difficulties entailed by Article 36 is that such a provision does not encompass many areas of the environmental policy. So the use of natural resources, or the conservation of natural resources, the development of renewable energy, recycling targets cannot be justified on the grounds of the justification listed under Article 36. So that's a fairly serious problem.
Okay, so if I understand you well, Article 36 is relatively narrow, and so it doesn't encompass all environmental policies.
To make matters worse, Article 36 is subject to a narrow interpretation. So it is settled case law that Article 36 cannot be interpreted broadly on the account that it departs from a general principle of the internal market.
And so this is why the Court of Justice came out with a new element, so mandatory requirements.
Yes, in Cassis de Dijon, the Court of Justice, as far as consumer protection was concerned, took the view that further requirements could be invoked by the member states with a view to justifying genuine protective measures. And so the Cassis de Dijon case law a few years later encompassed genuine environmental measures that could not be justified under Article 36. So today member states can justify their measures either in the light of Article 36 or in accordance with the case law on mandatory requirements of general interest.
And are mandatory requirements placed on equal footing with the grounds of justification of Article 36?
That's again a very relevant question, and it has been a very puzzling issues for now more than 25 years. As a matter of principle, measures that are entailing distinctions between domestic products and foreign products can be justified only on the ground of Article 36. Conversely, it's impossible for member states to justify, in accordance with a mandatory requirement of general interest, an environmental measures that's treating differently domestic products and foreign products.
Okay, so when we refer to all those justifications, we often use the criterion of indistinctively applicable. Is it difficult for member states to meet this criterion?
Yes, as a matter of course, many national measures do de facto treat differently foreign products for the sake of the distance, for the sake of the origin. So though there is no de jure differentiation, it's likely that there is a de facto distinction. And so again, as a matter of principle, such differentiating measures at the outset could not be justified in accordance with the mandatory requirements of general interest.
Do you really think that that difference matters, or is it much more of an academic debate?
I don't think it's still at the level of an academic debate. Different advocate generals, among whom Advocate General Jacobs and Geldhout have been raising concerns that the conditions for the two grounds of justifications were not placed upon equal footing. So they've been asking the court to reform its approach. Admittedly, the court has been implicitly endorsed the opinions of this Advocate General. So in recent judgments, one cannot really differentiate between what's distinctly or indistinctly applicable. So as far as environmental policy is concerned, the differentiation doesn't matter as much as it did a quarter century ago.
Okay, thank you. And are all those exceptions subject to limitations?
Yes. Again, we do face derogation to a general principle, freedom of trading in goods wherever within the internal market. Firstly, member states can reckon upon this justification inasmuch as the national measures are of non-economic nature. So Article 36, as well as the case law on requirements of general interest, enshrine the supremacy of non-commercial values over free trade. Admittedly, member states cannot claim that the environmental measures is aiming at the profitability of the plants or the national production. Such an argument would be immediately dismissed by the Court of Justice. Secondly, the member states are allowed to invoke this derogation inasmuch as the area has not been preempted by secondary law. In other words, the member states should verify whether there is no directive or regulations harmonizing the subject matter. And whenever harmonization took place or has been achieved, the member state is obliged to comply with the standards laid down by secondary law, and as a result cannot invoke Article 36, for example.
Do you have a concrete example?
Yes, the 1991 Walloon waste case is a good case in point, you know. Wallonia, in the aftermath of a series of environmental crises, decided to prohibit the import of not only Flemish waste, but waste produced be it in Germany or in France or in Luxembourg. And so Walloon waste could still be treated and even discarded in Walloon landfills. However, foreign waste or other Belgian waste could not be treated in Wallonia. The Commission took an infringement procedure against the Belgian states, claiming that the Walloon authorities were infringing Article 34 in banning the import of foreign waste. At that time, transfrontier movement of waste was not totally harmonized, but was only partially harmonized thanks to Directive 84/631 that was regulating transfrontier movement of waste, but exclusively of hazardous waste. That means that household waste or non-hazardous industrial waste was not regulated by that directive. So the Court of Justice, in adjudicating that case, endorsed a two-pronged approach. The Court of Justice reached a conclusion that Wallonia infringed the 1984 directive on the account that the directive allowed the member states to ban waste movement inasmuch as there were specific circumstances. So a total ban was not authorized by the directive. So moving on to the non-hazardous waste or to the household waste, the Court of Justice decided that given that the subject matter was not harmonized by secondary law, the Walloon authorities could invoke this requirement of general interest in order to ban the import of foreign waste. So one understands that the room for maneuver left to the member states is likely to increase or to decrease according to the deepening of EU harmonization.
Okay, thank you very much. A very last question. Are economic justifications accepted by the European Court of Justice?
No, not at all. They are fully discarded. So member states bear the brunt of the burden to demonstrate that their measures genuinely aim at protecting wildlife, ecosystems, the health of consumers, the health of children, and the like.
Okay, thank you very much, Professor. So this is the end of our last interview for this first series on Article 34, Article 35 and Article 36. So we basically started by saying that the principle of the free movements of goods is not absolute. Then we saw a first way to justify measures, so Article 36, we discussed its scope. And then we moved to the notion notion of mandatory requirements. It's important to keep in mind that they are not on equal footing, and that first comes Article 36 and then mandatory requirements, and then finally that economic justifications are not taken into consideration by the European Court of Justice. This interview was sponsored by the Chair Jean Monnet. For more information, please visit our website www.tradeversusenvironment.eu. You may also consult Professor de Sadeleer's book that is published by Oxford University Press. We will see you next week for a new series on the free movement of goods. Thank you very much and goodbye.